The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The first case is In-Re NP, and we will hear from the appellant. I want to be sure everybody is muted if you're not speaking.
Okay. Good morning. My name is Pete Wood, and I'd like to thank the Honorable Court for granting oral argument in this case. I am the appellate attorney for Kira Pridgeon. I was not the trial attorney on this case. I would like to reserve 10 minutes for rebuttal. So this is a appeal of a termination of parental rights case. And the sole issue before the court today is whether or not the trial court had subject matter jurisdiction to terminate parental rights. If the trial court had jurisdiction, then the order terminating Ms. Pridgeon's parental rights will stand. She will lose rights to her child, Nancy, the student. If the trial court did not have jurisdiction, then the order of termination is a nullity, and the remedy would be to vacate the order, remand to the trial division with instructions to dismiss the petition to terminate parental rights. This is a Uniform Child Custody Jurisdiction Enforcement Act case. That's a mouthful. I'm just going to call it the Act to save us time from now on. Every state and territory in the U.S. has adopted this Act word for word, except for Massachusetts and Puerto Rico. So because this is a case of first impression, we all had a rather daunting task of researching it. Basically, the act was passed by all of these jurisdictions to facilitate custody disputes between different states. Issues of child custody, visitation, termination of parental rights all fall underneath the act, and it's to give uniform laws and rules for this. So the issue before the court today, in a nutshell, there's been a lot of statutes, a lot of cases cited, is how is the home state of a child determined? And I would argue, so the trial court has to can only hear an action in the home state of the child. If it's not the home state of the child, the court has no subject matter jurisdiction. And without that, then there is no right to hear the case. I would argue this comes down to question of how we interpret the statute. Do we adopt it word for word, or do we adopt a more flexible approach? That is the mere presence of a child in a state enough to confer home state status, or do we need something more besides that? Do we need to consider the intent of the parties as well? So do we adapt a strict interpretation or a more flexible one? Most of the states in the U.S. have adopted a more flexible approach. So what happened in this case was in July 2017, my client lived in Virginia Beach. That's where she lived with her boyfriend. That's where the family lived. She had a job there. She had a home there. She was on vacation to Onslow County, which borders New Hanover County, and was pregnant with child. She had an emergency come up. She had to be airlifted to a hospital.
Mr. Wood, just as a matter of factual understanding of the record, I had understood it was the father's family lived in Virginia and certain portions of the mother's family lived in North Carolina. Is that right or wrong?
No, that's right.
All right, thank you. I mean, that's I want to make sure I don't lose you from the beginning.
No, it's a convoluted case, I think. father's family lived in Virginia Beach, but that's where she had made her home, and she had some extended family that lived in North Carolina. Yes, and she was visiting family down in Onslow County, but she had to be airlifted to the hospital in Wilmington, where she gave birth 23 weeks prematurely to Nancy. She wasn't expecting this to happen. Nobody was. So the next few months, she and the father live in the hospital. DSS eventually files a petition to take custody based on allegations of neglect and dependency. When Nancy is released from the hospital, my client and the father go back to Virginia Beach. The child stays in North Carolina in foster care.
So the order that I'm looking at from October 3rd of 2017 indicates that that both the mother and putative father are homeless. Is that correct?
I'm not sure because the court found different things. I think at that point they were in the hospital, but I think that my client's boyfriend's family still lived in Virginia Beach. I don't know. I would describe them as homeless. But if you look further in the record, every subsequent order until determination of parental rights order and every court report from DSS found that the parents lived in Virginia Beach.
No, but the point is, to me, that's an order that finds fact, and the finding of fact is homeless in Wilmington, both the mother and the father. Tell us about the hospital stay. Why did the father, the putative father, move in with the mother at the hospital?
He moved in with the mother at the hospital because he wanted to be near their newborn. That's my understanding. I have never spoken to the father, but that's just what I've gathered from the record, and that could be incorrect, but that's just sort of my interpretation of what went on. He did not appeal this case, and his attorney declined to participate in oral argument. But I would say, though, that every order, except for that initial order, found that the parents lived in Virginia Beach, and actually the termination of parental rights petition, October 22nd, 2018, alleged they lived in Virginia Beach. The summonses were served on them in Virginia Beach on December 10th, 2018. And
the real question here, at the time that the court exercised jurisdiction, which was the October 3rd order, the question is, at that time, did the court have subject matter jurisdiction in reference to this child? I mean, if you've got subject matter jurisdiction, you got it. If you don't have it, you don't have it. It's not one of those things you can have it and lose it, the way I understand it.
It's my understanding that the early orders were based on temporary emergency jurisdiction. And that was just because of the unusual circumstances. You had a child that was born premature, had severe medical issues, and the parents, based on the judgment of DSS, did not seem able to take care of Nancy at that point. So the early orders were based on temporary emergency jurisdiction.
Do you contend that the exercise of temporary emergency jurisdiction under Section 204 at the beginning of the abuse, neglect, and dependency proceeding was unlawful?
No, it was absolutely lawful. It was the right thing to do. I have no qualms with what the state of North Carolina did initially in this case. They treated my client very well. I mean, at state expense, she was airlifted to a hospital and given excellent medical care. And they did what they had to do. But
and the reason I asked that question is that at least your colleagues have cited some decisions, obviously from the Court of Appeals, that suggest that if a trial court initially exercises in a lawful manner emergency jurisdiction under Section 204, and then no other proceeding is instituted in any other state, the emergency jurisdiction essentially ripens into home state jurisdiction. I think that's an accurate characterization of their argument. If it isn't, they'll have a chance to tell me that I'm wrong.
Sure.
Do you understand their argument that way? And if so, why do you disagree?
Well, that is how I understand the argument as well. It's my contention that there's not any sort of ripening, that the state of North Carolina has something, there has to be something else besides that initial emergency jurisdiction. And most of the cases that they cite, something else happens. For example, the seminal case that deals with emergency jurisdiction is EXJ. And in that case, the mom moved here from Alabama, domestic violence situation. The court took jurisdiction based on temporary emergency jurisdiction. And then 2 years later, there's a termination action. But in that case, something else happened. Namely, that was the mom moved to North Carolina and lived here for 2 years. So my contention is they need something else besides that.
Doesn't EXJ also say, though, Mr. Wood, that if there's no custody order or proceeding that's been initiated in any other state, then the emergency state becomes the child's home state?
That's not my read on it, but that's one reason that we're here today, I think, is because most of the cases that we're citing are Court of Appeals decisions, and which are to a degree persuasive, and we're also citing jurisdictions, cases from other jurisdictions that are also persuasive. But that's not my read on the case. My read on the case is something else has to happen besides that emergency jurisdiction, which in EXJ.
I captured that from the DSS brief on page 18. So apparently you would disagree then with DSS's account that EXJ stands for the proposition that standing alone, if there's nothing else that is filed anywhere else in any other jurisdiction, then the emergency state becomes the home state. Is that one of your positions that conflicts with DSS?
Yes, my position is you need something else besides that initial emergency jurisdiction.
And just again, to make sure that we keep this member of the court, in a position where he's following your argument, is there anything in statutory language that suggests that this quote, additional occurrence requirement that you're suggesting that we adopt exists? I mean, what's the, other than the fact that you read the cases that to include that type of factual matter, is there anything in the statute or anything in the cases that specifically supports the establishment of an additional occurrence requirement?
Well, I would just point to the way that statute's been interpreted by other states and the way I would contend that EXJ interprets it. But there also is the statutes in general talk about that it has to be a home state of the child. If there is no home state, it's the state where the child has the most substantial connections to. And to me, it indicates that something else is needed. If I could just sort of jump to some other cases that have been cited. So a temporary hospital stay is not enough to confer jurisdiction, which is what we have in this case. And it's essentially, that's how it, and there's this case in Illinois, in Ray DS, where a mom had extensive DSS history in Illinois. 6 children were taken from her. She went across the state line to Indiana to give birth and to evade DSS. And eventually Illinois got wind. They filed an action against her. She asserted Indiana had jurisdiction. The appellate court in Illinois disagreed. They ruled that because her intent had never been to live in Indiana, that Illinois was the home state of the child, even though the child had lived in Indiana since birth before being brought back to Illinois. Another case with the same reasoning is 280RP, which is out of Missouri. In that case, you also had a child who was born in a different state. Mom lived in Missouri, where she had extensive DSS history. She hopped across the Mississippi River to Kansas City, Kansas, to evade DSS in Missouri, gave birth to a child. DSS in Missouri got word, filed a petition. Child was brought back to Missouri. She asserted that Kansas was the home state. Missouri said, no, that's not how it works. You have ties to this state. You only went there temporarily to avoid the jurisdiction of Missouri. And that brings up to me the two biggest public policy points for why we don't want to have this bright line test with the statute. And that is, number one, we want a child to grow up in a home, the home of the parents. And the reasons for that are fairly self-evident. That's where the home is, that's where the jobs are, that's where the family connections are, that's where the support system is. The other thing is...
Excuse me, Mr. Wood. Mr. Wood, I have a question about that. You talk about jobs, you talk about the home, you talk about a place to live. Can you point to me where there are jobs and homes in Virginia in the first case?
Well, her home was in Virginia.
No, sir. I mean, where there's a place to take that child, where there's a home that she can provide for that child, because what you're saying is the child needs a home. So where are those jobs and where is that home for that child in Virginia? Yeah, under the facts of this case.
The home would have been with the paternal grandparents, and there was an attempt to do a home study of their home, and they cooperated, but they were not licensed foster care parents. That's where they have been living before. And I do not have the employment history right here in front of me right now, but I do recall from the record that she did assert that she had a job up there. Now, living down here with your child for several months will probably disrupt any kind of employment when she was in the hospital.
But Mr. Wood, isn't it true that she had returned to Virginia shortly after the hospital stay, but now she's back in Virginia, or back in North Carolina, without a job and without at least the evidence of a home for this child?
I have no personal knowledge of that. This has all happened since the termination order, which was in April of 2019. So I don't know the current information. I have reason to believe that she's living in North Carolina, but I don't know if she has a job, to be honest with you.
You may have misspoke, Mr. Wood. What I'm talking about is from the time that custody was granted. She moved back to Virginia as soon as she was discharged from the hospital, and then she did return before the disposition of the TPR. She's been back and forth. I don't. So are you asserting there's permanency in Virginia with her going back and forth like that, and there's a job up there?
I don't know at this point if there's a job up there, but that's where the grandparents live. My argument today is that the court did not have subject matter jurisdiction at the date of the termination hearing. Now, a lot of things may have happened since then.
Is the key time at the date of the termination hearing or the date of the filing of the termination petition?
It's the date of the filing of the termination petition. There has to be subject matter jurisdiction at that day, so that has to be in a home state of the child at that time.
Well, you have to have jurisdiction under Section 201 at the time.
Yes, you do.
They may or may not be the same thing as the home state of the child.
Well, yes, it could be the home state of the child, or it could be, if there is no home state of the child, then we move on to the second thing, which is the state where the child has the substantial connections to.
Do you contend that any state other than North Carolina was ever the home state of the child?
I would contend that either Virginia is the home state of the child, and if the court does not find that, then I would contend that the child has no home state, and a situation like that, then the state with substantial connections to the child would be Virginia.
What is the statutory basis for your contention that Virginia would be the home state of the child at the time of termination?
My statutory determination would be 50, 201, 204, and 5107. But that's also
Can you cite me a specific state? Because each of those statutes has some, many of them have subparts. What is the statutory basis for finding that this child have a Virginia as a home state at the time of the termination?
I cannot point to that because the cases I cite in my brief speak to not having a strict reading of the statute and talk about how in these situations where somebody only has a hospital stay to tie them to a state, that should not be the home state of the child. And as I said before, another public policy reason is that, as in the two cases I cited, DS and RP, parent tried to avoid DSS custody by going to another state to give birth. And this seems to be a rather common issue. Just based on my experience, I can tell you it's not uncommon for parents with kids in DSS custody to hop county lines and state lines to give birth to a child so that child will not be under the control of DSS.
Has there, to your knowledge, is there a case that has the child ever physically lived in Virginia?
The child has never lived in Virginia.
Okay. Is there any case that holds that outside of the 1 or 2 day context of the 1, 2, 3 day hospital stay context, is there any holds that a state can have as his or her home state a state in which the child has never physically been?
Not in North Carolina, and that's one reason why the three briefs rely so extensively on cases.
And I'm sorry, I meant to ask you a state from another jurisdiction. Thank you for the correction.
Yes, sir. I mean, I did find a couple cases which to me are directly on point. The one, to me, RL out of California. In that case, a mom was from Mexico, went across the border to San Diego to give birth to a child because of the medical care there. DSS took custody in San Diego and had custody for over 2 years. Eventually filed a termination of parental rights. And the appellate court in California said that the home state of the child was not California because the mom never intended to live there. And DSS in that case argued that California had become the home state by virtue of DSS having custody. And California appellate court said, no, you can't do that. You can't bootstrap permanent jurisdiction based on temporary emergency jurisdiction.
Did they hold in that case that any state other than California was the home state, such as Mexico?
I don't recall, to be honest with you. I've read so many of these cases that they blur together to a certain degree.
Understand the problem. That's why I'm asking you some of these questions.
No. But RL was the main case. I will say, to me, the length of the time is not dispositive. It's the intent of the parents. To me, I look at a case like Hammond v. Hammond, where mom moved to Japan with all the kids and filed a custody action after living there for 6 months. And the North Carolina Court of Appeals said that Japan had not become the home state because the intent had never been for the parents to live there permanently. A case cited by Appleese is Thierry out of Texas. And in Thierry, a mom moved from New Jersey to Texas, lived there for 8 months. And there was no custody order in New Jersey at that point. There was at one point, but that case was closed. And also lived in Illinois for a week, went back to New Jersey for 3 weeks, but lived the bulk of the 8 months in Texas. And the Texas appellate court said that Texas did not become the home state because the intent of the mom was not clear. That it was unclear if these visits to Illinois and New Jersey, and for that matter, to stay in Texas, if it was not clear whether or not those were permanent moves or temporary absences. So they could not discern what her intent was. So they ruled that Texas was not the home state and she could not file an action there.
I don't want to take you too deeply into your rebuttal time, but I do want to get this straight. You say in a couple of places in your brief that, quote, at some point, unquote, North Carolina no longer had emergency temporary jurisdiction and that its jurisdiction had expired. When would that point be in your estimation?
Well, I may have misspoke about that. I don't know. At some point, emergency jurisdiction does expire. There's a number of cases that say that, and I would say it's when the emergency ends. More often than not, it seems to be when the parents move to the state. That's the main thing that seems to end temporary emergency jurisdiction.
Was there anything here that triggered the emergency jurisdiction to expire in terms of a motion being filed or any seminal event that would have caused it to expire?
No, there was not, and I think in rethinking my position that North Carolina could basically string together a bunch of orders based on temporary emergency jurisdiction until that ended. That would probably take some sort of hearing for it to end, where you could prove that the emergency no longer existed. I think they cannot do a termination of parental rights order based on temporary emergency jurisdiction, though. And I have
can I jump in for just a second? At the time that the petition for termination was filed, was the child in the legal custody of the Department of Social Services?
Yes.
And placed in the foster home? Okay.
Yes. And I'm going to stop here and reserve the rest of my time for rebuttal. Thank you very much.
Thank you, counsel. We'll hear from the FLE. I understand that both counsel will argue, and I will not intervene as you make the transition from one counsel to the next. So now we'll hear from the FLE.
Thank you, Your Honor. Justices, my name is Karen Richards. I am a member of the New Hanover County Bar. I am representing the petitioner, New Hanover County Department of DSS. I'll be splitting the time with Ms. Lynch, the GAL, for 15 minutes each. It is my pleasure and honor to be in front of you and have this opportunity to be heard on this issue. I'd ask that you affirm the trial court's decision. North Carolina had subject matter jurisdiction at the initial filing via the home state statutes under the UCCJEA. In addition, that child never lived in Virginia, has no touches, no significant connections, and no substantial evidence as to any connections to Virginia. And playing off of what Mr. Wood said, Mom was not just driving through this state. I believe it was Justice Irvin that pointed out she was visiting family in this state. Mom's maternal family, her foster family, is all in Onslow and Pender County. So she had that connection. While she was here, she did give birth. And I believe that any kind of determination under the UCCJEA or 280A19-1 through 204 starts with the physical presence of that child. You have to start somewhere. You have to start where that child is. That child has been in North Carolina. That child has never left North Carolina. The child did not come into custody until after 3 months when Mom had been residing in North Carolina. Mom and Dad were evicted from a home in Virginia, that home being the paternal grandparents, who eventually did not get approval through the ICPC process. So there was no home for them to return to in Virginia, which would be that they were homeless at the time. Mom used a North Carolina address for her affidavit of indigency for court-appointed counsel. She gave several North Carolina addresses as placement and when the department took custody. And she said, if you want to use Mr. Wood's argument of intent, that she did intend to stay in North Carolina. Dad then joined her. The department took custody in October 2017 on the 3rd, and parents remained in North Carolina until they left in November of 2017. So the state, if looking at 50A 201, you have 4 options to get state home state jurisdiction. One would be 6 months before, after. Obviously, we don't have that from before, but after, we have at least 4 months where the child resided with a parent in North Carolina. And then once the child came into custody, she essentially, as January 2018, became a home state for her. She was a resident of North Carolina, had no other touches at that time.
Ms. Richards, at least if I understood Mr. Wood correctly, we ate up a lot of his rebuttal time, but we'll have some time maybe to tell me if I'm wrong. His argument appears to be that given that the child was taken from the parents by DSS, that the fact that on the basis of emergency jurisdiction, that jurisdiction can never ripen, and that's my word, into a basis for finding home state jurisdiction. And I had a discussion about why he contended that. Presumably, you think that's incorrect. Why would you argue that that's incorrect?
Thank you, Your Honor. I believe that's incorrect because if you look at the statutes, they're talking about where the child is located. And by the time that child lived in North Carolina for 6 years, that emergency jurisdiction then ripens into home state jurisdiction.
6 years or 6 years or 6 months?
I apologize. 6 months. Clearly misspoke on that standard. After 6 months, it would become the home state of the child. In addition to,
let me jump in and ask you something. I know we've talked a lot about the UCCJEA and the definitions of home state and that kind of thing, but I'm wondering what's the role of 7B1101 jurisdiction provisions here? Because it says that the court shall have exclusive jurisdiction to hear and determine any petition or motion related to termination of parental rights to any juvenile who resides in or is found in the legal or actual custody of a county department of social services at the time of filing of the petition. And then later in that section, it says that the court has jurisdiction to terminate irrespective of the state of residence of the parent. Why is that section, how does that section fit into this?
Yes, ma'am. I believe that under that section, the TPR, we cannot just take emergency jurisdiction and then immediately terminate parental rights. There has to be some sort of jurisdictional issue, which in this case has occurred because of the home state status. The child achieved home state, North Carolina achieved home state status of the child after the 6 months of her being in emergency custody in the JA case. At the time of the filing of the petition for the TPR case, this North Carolina was her home state, irrespective of where the parents lived, as set out in that statute. So at the filing, 280A19-1 would be the controlling statute for jurisdiction for the TPR under 7B1101. It was my belief that it would no longer be emergency. Thank you.
Okay, thank you.
In addition to the having ripened into the 6 months, if you don't that the initial custody taking, the commencement of the JA case, that there was a home state jurisdiction of time being 6 months, then you move on to, if no other state has jurisdiction, are there significant connections to North Carolina or substantial evidence of that child's care, protection, and relationship? It does not talk about the parents' connections. It talks about the child as the primary, that's the polar star, as some of the case law has said, as to what are their connections. And there was maternal family, as I believe Justice Hudson brought back, I believe it was her, that mom, or it was Justice Berenger, mom did return and lived with that family at the time of the TPR. Mr. Wood was incorrect on when they were served. The summons did for the TPR go to Virginia, but they had already returned to North Carolina and did not let the department know. They were served on December 10th in New Hanover County at a hearing. So they were served for the TPR in North Carolina. They were residing in North Carolina. So, and the child had been here for 6 months at the TPR disposition for sure, and shortly thereafter of the filing of the TPR. So to get to that, you had to go back to look to the JA case. and the significant connections and substantial evidence is all North Carolina for the child. She has no touches to Virginia except paternal family. When she returned to North Carolina, during the JA case, after she left North Carolina to go to Virginia, she did not have a job. They provided one pay stub for verification. She was doing temporary work. And they were trying to live with the paternal grandparents. And as I said before, the ICPC fell apart. The third prong.
I'm sorry. I just would like to make sure that I understand whether there's potentially any unintended consequences of a rule about temporary jurisdiction ripening into home state jurisdiction or home state status and jurisdiction for a termination action. And my question is, on the argument that you're making, would it be that in every case where there's temporary emergency jurisdiction, if the child is not either returned to the parents or otherwise moves to a different state, that there would always be then home state status after 6 months?
Thank you, Justice Earls. No, ma'am. It would be if the other state would come and intervene. If another state had jurisdiction and they could prove or are requested to be to take the case or the child there. So if Virginia had been accessed by the parents and said, this is our home state, and petitioned the court and a motion was filed to transfer the case, or had the parents made the request to transfer custody from North Carolina DSS through the ICPC process to Virginia to them, if Virginia took jurisdiction and came to North Carolina and could establish the 4 things that are set out through our codification of the UCCJEA, then Virginia would have had that opportunity to essentially interrupt the ripening of emergency jurisdiction into home state jurisdiction. So it wouldn't be a bright line rule, but you have to start somewhere. And it's my contention, I believe my co-counsels, that you start where the child is first located, and then you work through everything. You have to have a starting point. And that starting point is, does the child where the child was born, is that the home state? And if not, then you move forward. If there is no home state, as some of the cases.
Before we move on from Justice Earls' question, which was one I was probably going to ask as well, let's say we have a parent in the position that we have the respondent mother in this case. Could she have filed anything in Virginia that would cause Virginia to assert status, assert authority in the event that it had any?
I would tell you that I am ignorant to that answer, Justice Ervin. I believe
that's always a fair answer.
I believe that if she intended to access the Virginia courts and claim that they had jurisdiction, Virginia has to have an order to tell North Carolina to release that jurisdiction so it doesn't either ripen or it's returned to the proper state. As to the procedure, I apologize that I cannot give you a valid answer on that.
Thank you.
You stated a number of statutes that would indicate that North Carolina would have jurisdiction over this matter. Are you saying that there are overlapping statutes that would give this, or would you say there is a definitive statute that would give North Carolina jurisdiction? And if there is, which one would that specifically be?
And Justice Morgan, would you mean overlapping like you needed to work through a ladder step, or just that they're conflicting?
Not that they're conflicting, but that they are actually not conflicting from the standpoint of looking at the fact that, for example, the child was born here in the state and there was never a motion that was filed or any other intervening episode that would terminate emergency jurisdiction. So it therefore morphed, to use the term that was used in your brief, into home state jurisdiction. Also, the aspect that the child never lived anywhere else. So as a result, there would be home state jurisdiction. So I'm looking to find out which one you would say would be the definitive statute to support your claim, or are you saying that in conjunction with each other, it fortifies the position of DSS in looking at multiple statutes.
To use your words, Justice Morgan, I believe it would be that they in conjunction and they would fortify each other, because home state is temporary jurisdiction turns into home state. And you can see that in 280A19-1 and at the, I believe it would be in Part B, just glancing at it, that if no other state has if an action, a child custody proceeding has not been or is not commenced in a court of a state having jurisdiction, child custody determination made under this section becomes a final determination, and this state becomes the home state of the child. So anything temporary jurisdiction, 50A204B would be that controlling the I don't know that respondent mother contends. We actually have that language that tells you when that happens. And then the definition for home state, to piggyback off of that, would come out of 50A201. And in that, you would do your ladder steps. Hence my question as to, has that child been here for 6 months? Or if another state doesn't have jurisdiction, is there significant contacts and substantial evidence? Or if all courts having jurisdiction have declined and found North Carolina to be the most appropriate forum to determine custody, then they've relegated jurisdiction here. Or 4, no other state would have jurisdiction under the criteria, so North Carolina becomes that home state. Those are all ors, not ands. So I believe 50A204 is bolstered by 201 if we have temporary jurisdiction. It'd be my contention that we had home state based on 201, that under A2, where the connections and the evidence, and under no other court has had jurisdiction because no filings are happened at that time. I do want to not cut into Ms. Lynch's time, so if there's any further questions, I'd like to defer over to her.
Thank you. Chief Justice Newby and Associate Justices, may it please the court, I'm Michelle Formival Lynch, and I represent the guardian ad litem in this appeal. And we would submit that the facts of this case show that under the UCCJEA, North Carolina was the home state of the child at the time the original juvenile petition was filed and at the time of the filing of the TPR petition. I will focus on the issue of whether North Carolina was the home state of the juvenile Nancy at the time of the filing of the TPR petition. It is undisputed that the trial court had temporary emergency jurisdiction at the time of the filing of the petition on October 3rd, 2017. The respondent mother, in her brief, stated that she did not contest the fact that the trial court had temporary emergency jurisdiction under 50A204 on that date. Respondent mother does argue that this jurisdiction expired at some point before the TPR petition was filed, but she never states a definite point in time in which this allegedly happened. Respondent mother has not pointed us to any statute or case law which states that temporary emergency jurisdiction evaporates at a certain point in time. While it is our contention that North Carolina was the home state of Nancy at the time of the original neglect and dependency petition, we submit that if this court finds to the contrary, in the alternative, North Carolina was the home state by the time the TPR petition was filed. Therefore, the trial court had jurisdiction and the TPR order should be affirmed. The facts show that Nancy had been present in North Carolina since her premature birth on July 4th, 2017. Due to her condition, she was in the hospital with her mother until she was 3 months old. Upon leaving the hospital on October 12, 2017, she was in DSS custody and went directly into the care of her foster parents in New Hanover County. In the adjudication order of January 2018, where the court adjudicated Nancy neglected and dependent, the trial court stated that it had jurisdiction since no court action has been initiated in any other jurisdiction concerning the juvenile. This is in the record on page 56. The court continued exercising jurisdiction, and by the time the TPR petition was filed in October 2018, Nancy had lived with her foster parents in North Carolina for over a year. Under the UCCJEA, the home state is defined as a state in which a child lived with a parent or a person acting as a parent for at least 6 consecutive months immediately before the commencement of a child custody proceeding. Nancy's foster parents meet the statutory definition of persons acting as a parent. Therefore, the trial court was correct in finding in the TPR order that it had home state jurisdiction, and under 280A19-1, as Nancy had lived in North Carolina with her foster parents for 18 months by the time the TPR order was filed. There are 3 cases from our Court of Appeals that are similar to the present case, and in all 3 of those, the court held that while the trial court originally had temporary emergency jurisdiction, it eventually attained home state jurisdiction due to the fact that the child was in the custody of a parent or a person acting as a parent in the state for at least 6 consecutive months prior to the action being commenced, and no other state had obtained or asserted jurisdiction.
Ms. Lynch, in my conversation with Mr. Wood, he suggested that, one, I think he was suggesting that he thought this case was only decided because he didn't think it was appropriate for temporary emergency custody to transmute itself into, permanent custody. And secondly, that even if we didn't agree with that, that there was an implicit requirement in those cases that there be some additional recurrence beyond the passage of time. What would you say in response to that set of arguments?
I would say that temporary emergency jurisdiction does not turn into home state jurisdiction. What happens is they overlap, because once the child has been here and in the custody of a parent or a person acting as a parent for 6 months, then North Carolina becomes the home state. And the cases that I am referencing to, the 3 cases, are NRA, MB, EXJ, which was affirmed by this court, and NT. And in all of those, the trial court originally had jurisdiction by temporary emergency jurisdiction. But then, because the child continued to be present in this state with a parent or person acting as a parent for 6 months, North Carolina, by those facts, became the home state. The only other way that North Carolina would not have jurisdiction is if there was another action in another state that had significant connection, or if Nancy had been removed to that state for some reason. There can be the fact that there is no home state, that no state can be the home state. But in that case, there has to be some type of significant connection for another state to take jurisdiction. In this case, Nancy never lived anywhere besides North Carolina, and we have cited cases that even though the mother was pregnant with Nancy while she was in Virginia, certain states have found that does not count towards the home state jurisdiction finding. Like I said, I was going to focus more on home state jurisdiction at the time of the TPR, but I think it's worth mentioning that all the cases that have been cited that concern a hospital stay was a very brief hospital stay. And in this case, Nancy was in the hospital for 3 months, which was prolonged, and her mother was there with her in the hospital. So we would assert that under the UCCJA, for the rule of a child that is under 6 months old, North Carolina did qualify as the home state. But if this court were to not find that to be the case, then immediately when DSS took custody and she came out of the hospital October 12th and went into the custody of her foster parents, you would start counting at that point the passage of time, that 6 months, when you look for home state jurisdiction. In the January 2018 order, the court did not specifically make a finding that it had home state jurisdiction, but it did point out that no other state had asserted jurisdiction. Therefore, although it did not explicitly spell that out, we can assume that there had been some communication that possibly someone had checked, and no other action had been commenced, and certainly no action could have commenced before the child was born. So our court it was clear to our court that no other state had jurisdiction at that point. So
Just quickly, is it your argument that the determinative factor is, in a situation like this, or in this particular one, is that no other state became involved after North Carolina had entered the custody order and placed the child in foster care?
I think that that would have to be considered, because I don't think it's the determinative factor. I think what you look at here is home state jurisdiction. Were those requirements met? Yes, they were. When you look at temporary emergency jurisdiction, the 204 section, it states that if jurisdiction was taken under emergency, it just doesn't go away unless there is an action filed in another state or an order entered in another state. And in that case, temporary jurisdiction may go away. So I think the definitive thing you look at is the home state. But if you're looking at temporary emergency jurisdiction, you have to just look at 204. And another state may come into play as to whether that jurisdiction did expire.
Well, it doesn't, in 204B, the last sentence says that the state becomes the home state if no other state has entered an order. Is that not what you're saying?
No, that is correct.
Okay. It's a sort of a confusing network of statutory sections.
Yeah, it is. There is a lot here.
Appreciate your guiding us through it.
The first case that I was going to mention that's similar to the case that we are looking at here is In Re MB, which was decided in 1999. In that case, the petition was filed when the mother and 5-month-old child had been living in North Carolina only a few weeks. They had moved from the state of New York. The trial court found that the child was neglected in an order just 2 months later, and the father appealed. Between the notice of appeal and the Court of Appeals opinion, the trial court received notice from New York that there were no pending matters or orders concerning the child in that state. The trial court then entered an order on jurisdiction, finding that North Carolina was the child's home state because the child and her parents had been physically present in North Carolina for more than 6 months. Our Court of Appeals therefore found that the issue was moot. The trial court had properly exercised temporary emergency jurisdiction, and North Carolina became the home state after the parties remained here for 6 months. The court held that the October 2005 order was proper, and the temporary child custody determination of June 2005 was now a final order of custody. Based on this case, the Court of Appeals held similarly in In Re EXJ, which was affirmed by per curiam by this court. It held that after there was original temporary emergency jurisdiction, the trial court had home state jurisdiction for the TPR since the children and their mother had been present and living in North Carolina for 2 years by the time the filing of the TPR petition, and there were no other proceedings or orders in other states. The Court of Appeals found that the trial court had competent jurisdiction in the beginning by temporary emergency jurisdiction. The parents argued that emergency jurisdiction is temporary and did not allow for jurisdiction in a TPR. The court noted that under the statute on temporary emergency jurisdiction, if there is no previous child custody determination entitled to be enforced, and a child custody proceeding has not been commenced in a court of state having jurisdiction, a child custody determination made under this section remains in effect until an order is obtained from a court of a state having jurisdiction. Because no other state had obtained jurisdiction under the UCCJEA, prior custody orders remained in effect, and DSS had standing to file the TPR petition because by that point, the court had attained home state jurisdiction. In NRA NTU, North Carolina had emergency jurisdiction when the mother left her home state of South Carolina and was arrested for bank robbery in September 2011 in North Carolina. While the child was with her, the child was taken into DSS custody. The trial court recognized that South Carolina was the home state in two subsequent non-secure custody orders and the adjudication order of December 2011, but also stated that it had temporary emergency jurisdiction. A review hearing was conducted and a TPR petition was filed the following April. Well, in April 2013. The TPR order was filed in September 13. On appeal, the Court of Appeals found that no action had been filed or orders entered in another state. The child had been living in North Carolina with his foster parents since September 2011, 18 months prior to the TPR petition being filed. Therefore, North Carolina was the home state and the court had jurisdiction for the TPR. Respondent mother has not shown that temporary emergency jurisdiction in this case expired. Once exercised, it cannot expire until another state takes jurisdiction or enters orders, or this state becomes a home state. Neither the first two regarding another state never applied to the present action. In summary, it is clear that the trial court had temporary emergency jurisdiction when it entered the initial order, and respondent mother has not disputed this fact. Jurisdiction originally taken did not expire or simply disappear. The UCCJA makes it clear this jurisdiction continues. By the time the TPR petition was filed, North Carolina had jurisdiction as it qualified as the home state of Nancy. Accordingly, jurisdiction never expired under the UCCJA, and the order of the trial court should be affirmed.
Thank you so much. Appreciate it. We'll hear rebuttal.
Mr. Wood, you're on mute.
I'm sorry. Let me just go through the three cases real quick. EXJ and MB, in both of those, it wasn't just the court orders from other states. It was also the fact that parents had moved to North Carolina. So to me, that was the thing that changed the temporary to permanent jurisdiction, was the parents that lived here for an extended period of time in both of those cases. NTU is a problem from my perspective, and I think that case was wrongly decided. NTU held that the foster parents would be considered the caretakers for purposes of home state jurisdiction. I think it's one of those situations where bad facts make bad law. The mom in NTU wasn't just charged with armed robbery. She was charged with murder. She wasn't getting out of jail. So that was never going to work out. I'd also point out that she moved to North Carolina with the child, unlike my situation where my client came here not knowing she was going to have a child right away. So I would urge the court to adopt the rationale of RL out of California rather than NTU. Just as Justice Earls points out, the law of unintended consequences looms very large. We don't want to create a situation where a parent can evade DSS custody by going to another state and just letting the passage of time control things. Nor do we want to create a situation where a parent can leave the state and go, to Guam or California or somewhere else, and then assert custody in that state just based on the mere passage of time. That would lead to some very unjust results, which is why I think that these statutes need to have some flexibility to them. It's important in criticizing my client to remember she was 17 years of age when she came here. She was a minor. And her her means and her thinking were not those of an adult. And to hold her to the standard of an adult, I think, is not entirely fair. She is an adult now, and I think she's getting her life back together. But at the time, she was 17 years of age. There's also been some points made that the mom should have contacted Virginia and actually should have been initiated up there. These other cases where DSS in one state found out about a hospital birth, there was already a DSS history in the first state. In DS, where the mom had a history in Illinois, and in RP, where the mom had a history in Missouri. There was no DSS history up in Virginia, so no one had any reason to, from that state, looking to see what was happening down here. I would submit that if you have an agency whose duty is to look out for the best interests of the child and to reunify the family, that some of this burden should fall on them. That is not unreasonable to expect them to contact DSS up in Virginia and to tell them, hey, look, we have a child here. From what we can tell, the parents live in Virginia. Putting that to the 17-year-old who's giving birth early, to me, would lead to an unjust result. So let me just once again point out there should be no automatic ripening of emergency jurisdiction, and that the court should take a more flexible approach to home state status. Thank you very much.
Thank you, counsel. Thank you, everybody. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court.
Ah.